And it seems to me that the answer is most Australians think that human rights are important, but what they really mean is that their human rights are important, and the human rights of their friends and their family are important, and the human rights of their neighbours and people they like are important. But when it comes to the human rights of people they're not so sure of, people with different coloured skin, people with different religion, people who've come from places whose names they can't even pronounce, then their human rights don't matter quite as much. And if they've got a mental disability, or if they're Aboriginal, or if they're unemployed, well, then their human rights don't matter as much either. And that's the kind of thinking which seems to me to provide the only possible explanation for the fact that Australia was indifferent to the plight of the stolen generations, to the plight of asylum seekers, to the plight of David Hicks, and to the plight of many other people, unpopular minorities at the fringes of our society. A Human Rights Act at federal level would mostly help unpopular minorities, because governments in this country typically do not trash the human rights of people like us. It's usually other people. People like us matter because electorally we matter to governments. People who are unpopular at the margins of society are politically irrelevant, and so their rights can readily be trampled on by governments who think that there's an electoral advantage in doing so. So Cardinal Pell is right. Minorities would be advantaged more than the complacent majority like us. But that's as it should be, because the point about human rights is that they belong to us not because we're nice, not because we're pleasant people, not because we're middle class or white or Christian, but because we're human. And asylum seekers are human just the way we are, and their human rights are just as important as ours. And if a Human Rights Act means that people at the unpopular fringes of society get some additional protection, then that's as it should be. And what surprises me is that a person of the cloth should argue that a Human Rights Act is inappropriate because it transfers power to minorities. What part of the parable of the Good Samaritan has Cardinal Pell forgotten? What part of the Sermon on the Mount has he forgotten or misunderstood? I would have thought that it's entirely consistent with the doctrines that he adheres to, that minorities ought to be protected where they need to be. The next argument is that they don't work. And these days it's fashionable and popular to point to Zimbabwe as an example of a country that has a Bill of Rights and which is in complete chaos. And the former Soviet Union, likewise, had a Bill of Rights, but terrible things happened there. But that is not an argument that bills of rights don't work. That's an argument that when the rule of law fails, nothing will help you. If the rule of law fails, as it has in Zimbabwe, as it did in the Soviet Union, then a Bill of Rights won't help, a constitution won't help, nothing in writing will help. It's all down to realpolitik at that point. Don't be fooled. In a country where the rule of law is strong, as it is in Australia, a Bill of Rights will make a significant difference. And finally, my favourite argument, since I'm a lawyer, is that it will be a lawyer's feast. And I like this because one of my interests outside the law is an interest in language and the meaning of words, and there's a neat linguistic trick in the lawyer's feast argument. When people hear that a Bill of Rights will be a lawyer's feast, they immediately think, well, that's no good. Why? Because lawyers, as we all know, are nasty, grasping, greedy, horrible people, and feasts are nice. And we don't want nice things happening to nasty, greedy, grasping, horrible people. Therefore, a lawyer's feast has to be bad. But the argument's wrong. And it's wrong, I'm not going into bat for lawyers, and I do enjoy feasts, but it's wrong because in Australia, human rights work is generally unfunded. You generally do it for no pay or for drastically cut rates, mainly because it's only the rights of unpopular minorities that are generally at risk. And they usually don't have the resources either to fight for themselves or to pay someone else to fight for them. So typically, and I'm sure Jeremy will agree with this, you don't get paid for doing human rights work. Now, if that's a feast, then let's avoid a famine. And frankly, I think I'm cynical enough about lawyers to say I don't expect to see large numbers of lawyers queuing up to do unpaid work in support of human rights. In conclusion, can I say this? When you're looking at the question of a Human Rights Act for Australia, please be very clear about what it is and what it is not. Be very clear that it does not distort the fabric of our democratic arrangements. It does not transfer any power to judges. It always leaves the final word to the Parliament. It will help minorities, and they are minorities whose rights matter, because at the moment, and during the political debate that will precede the government's decision about whether or not to introduce human rights legislation in Australia, we have to face up to one single clear question. Do we believe in a fair go just for us, or do we believe in a fair go for everyone? Thank you.
Well, thank you, Julian, for such a thought-provoking and highly persuasive start to today's conversation. Now, the way in which the rest of today is going to run is I'm going to spend a little bit of time to give some context to Jeremy's work and position and explain the Woomera Lawyers Group. I'll then hand over to Jeremy to talk a little bit about why he takes the position of being unconvinced by the need for a Bill of Rights in Australia, and then Julian and Jeremy will engage in a conversation. The Woomera Lawyers Group was the first group to take up the fight for a fair deal for the wave of boat refugees from the Middle East who started coming to Australia in about 1999. The group, with the support of Centrecare, Anglicare, the United Church and the Salvation Army, just to name a few, got organised and provided representation for refugees who were detained at the Woomera Detention Centre. A war in the media began, and the group started telling Australians and the world about the human rights abuses. The group then commenced court cases to overturn the Howard government's outrageous decisions declaring that the refugees were frauds. The group thought globally and acted locally. They won some cases. Then Tampa and the Pacific Solution occurred. Then 9/11 occurred. Then the Howard government changed the law, and then there was a long line of losses. However, they were the group that commenced and won some of the big refugee cases. The case of Al Masri on the 15th of August 2002 in the federal court, where there was an order that a particular asylum seeker, Akram Al Masri, was released from the Woomera Detention Centre on the basis that he was being detained illegally. A big win. There was the case of B&B, where the full court of the Family Court on the 25th of August 2002 released the children who were being held in detention. They had been at Woomera when the proceedings were issued. So by these and other of the group's actions, they planted the seeds in the community and also saw numerous other groups being created to take up the good fight for justice for boat people, including RASA, the Refugee Advocacy Service of South Australia, Circle of Friends and Rural Australians for Refugees. The Woomera Lawyers Group was successful in mainly three ways. First, it focused on the human rights abuses of the Howard government upon Middle Eastern boat refugees in a credible and influential way. Secondly, it was pivotal in getting children out of detention and closing down the Woomera Detention Centre, which occurred on the 17th of May 2003. Thirdly, it provided a model for action that others followed. Jeremy Moore and Paul Boylan were the co-founders of the Woomera Lawyers Group. They were both inspired by the maxim, "If it is to be, it is up to me." Please welcome Jeremy Moore.
I acknowledge the Kaurna people as the traditional owners of this land that we're on today. And I also acknowledge all the people that were part of the Woomera Lawyers Group. The group was huge. It included a couple of hundred lawyers and hundreds of other people who were from different backgrounds, such as interpreters and teachers. My wife, Jane Moore, who was then a social worker and is now a lawyer, and Paul Boylan and an interpreter called Ahmed Hashimi were the first legal team to go into the Woomera Detention Centre on the 1st of December 2000. And they went there to get a true sense of how bad things were in the centre and to work out what, if anything, could be done to help the people that were detained there.